Muy buenos días, tengan todos. Muchas gracias por seguirnos en este segundo Foro Internacional de la
Good morning,
Innovación en
everyone.
la
Thank you for following
Justicia,
us in this
organizado
second
por México
International
Evalúa
Forum
y la
on
Fundación
Justice
Friedrich
Innovation
Naumann.
organized by Mexico Evalúa
Agradecemos a todos los
and
que nos siguen
Frederick Naumann
acompañando
Foundation.
y
I
por
would like to
favor
thank everyone who is
síganos en
still with
nuestras redes
us
sociales de México
and please
Evalúa,
follow us
igual
on
en
our
nuestra página
social
de YouTube.
media in Mexico
En este
Evalúa and
segundo
our
día del
YouTube
Foro
channel.
Internacional de Innovación en la
This is the second
Justicia,
day of
estaremos
this
discutiendo
forum
y
on justice
analizando las
innovation, and we
diferentes
will be
formas en las
discussing
que
and
la
analyzing the
tecnología y la
different ways
innovación
in which
pueden facilitar el
technology
acceso a la
and
justicia.
innovation can
En
facilitate
este primer
access to
panel
justice. In this
platicaremos de la
first
justicia
panel, we
global,
will talk
cómo
about
garantizar el
global
acceso a la
justice and how
justicia
to
ante las
guarantee access to
desigualdades y la
justice
migración.
before
Nos
inequality and
acompañan
migration.
Alberto Pradrilla, de
We
Animal
have Alberto
Político,
Pradrilla from
como
Animal
moderador,
Político as our
Susan
facilitator,
Golesorki,
Lara
fundadora y
Susan
directora
Golesorki,
ejecutiva
who is
del
the
Centro
founder
para la
and
Migración,
CEO for
Género
the
y
Center
Justicia,
for Migration,
y
Gender
Felipe
and
González
Justice,
Morales,
and Felipe
de las
Gonzalez
Naciones Unidas
Morales
sobre los Derechos
from
Humanos de los
UN
Migrantes.
for Human Rights
Muchísimas
for
gracias.
Migrants.
Muy buen día.
Thank you very much and have a great day. Hello, good morning, and thank you for being with us. Today, we will be talking about access to justice and migration in a context of great difficulties, both here in Mexico and in the whole region. We need to consider that the last few years have been of really harsh policies against migrant populations, both here in Mexico and in the whole region, but we may consider the agreements between Mexico and the United States to stop the flow of migrants from the previous administration in the US and the current administration as well. Just to give you some information, in September, there were more than 41,000 people arrested here in Mexico because they were in irregular conditions as migrants. This is the highest figure we have had in the history since we have these records, which allows us to see that currently we have this policy of stopping the movement of people that are running away from violence, poverty, or other elements such as climate change, maybe, that has affected some areas in Guatemala, Honduras, and El Salvador. These policies for stopping migration may bring severe violations to human rights for those people who are in movement. And we may remember a few months ago how people that were in the different caravans in Chiapas were victims of different law enforcement officers that were beating up these migrants. We saw these images of these people, and there were a lot of violations to human rights that is within this context of mobility of migrants. And sometimes they do not have access to justice, and without access to human rights. Just this year in Mexico, we have had two events that have been severe violations to the human rights of migrants, such as the Camargo massacre in January, in which 19 people lost their lives, 2 Mexican people, and all the rest of them were from Central America. And there is a great difficulty for the families of these migrant people that were about to reach the United States when they were slaughtered. And we have 12 police officers that are arrested. These families not necessarily have access to justice and to the information of what was happening because of the obstacles that the justice system is placing. The same thing happened recently when this Cuban migrant, Cristobal, died, killed by an element of the National Guard in Chiapas when he was in a vehicle in Vijijiapan. Once again, for his family, it's being very difficult to have access to justice and also having the certainty of being able to recognize the body and having access or to recover the body or making the procedures that are necessary in this unfortunate situation. and also to talk about the justice and migration issues, also about the impact that the new technologies have in this context. We have a panel with Felipe Gonzalez Morales and Susan Olescorgi. Lara Susan is going to tell us. She is an assistant professor of political sciences and co-director of the program of gender studies of women and sexuality in the University of Portland in the US. Her line of work is in topics related to intersection, migration, and gender in a global context. Her last papers were on the protection and also for Muslim women that are facing this question, European identity, nationalism, and women in the situation in Venezuela. This is about the efforts of the civil society and also the role of the UN in ideas for peace. She is also the founder, the CEO, and promotion director of the Center for Migration in Gender and Justice. This is an NGO and a nonprofit organization that is in charge of migrants, gender, through research and promotion of information. And she was also the facilitator in a forum of equality from the UN, and she has been part of leadership programs from the Center for Migration and Justice that trains young migrants against gender violence. With no further comments, I will give her the floor. So we allow her to start this panel. Thank you very much for your participation, and the microphone is yours.
Thank you very much for having me and for providing a platform to share my work. I'm Dr. Lara Susan Golizorki, Assistant Professor of Political Science and Global Affairs, Gender, Women, and Sexuality Studies, as was just mentioned, as well as the founder, Executive Director, and Advocacy Director at the Center for Migration, Gender and Justice, a nonprofit that addresses human rights at the intersection of migration and gender. I'm honored to address pressing questions on matters of justice in the context of migration amongst such esteemed panelists. As a migrant woman myself, coming from a family that has been displaced over space and time, matters of justice are imperative to my being, to my work as a scholar, as an educator, and also in my work as an activist. So for today's discussion, I would like to speak to the intersection of migration and gender and how matters of justice, or maybe more so injustice, operate within that. Next slide, please. So when we speak in matters of justice in the context of migration and gender, it is important to acknowledge the varied experiences that exist at this intersection. And so this includes justice for regular migrants, irregular migrants, asylum seekers, refugees, displaced persons, justice for women, justice for girls, for LGBTQIA+ persons, and for gender diverse persons. Next slide, please. Or in other words, we can speak of justice for all that experience injustices at the intersection of migration and gender. And so in this way, the vision of gender justice beyond borders means also gender justice beyond binaries. But unfortunately, gender justice beyond borders remains a goal yet to be achieved. Women, girl, LGBTQIA+, and gender diverse migrants are at heightened risk of violence, vulnerability, and marginalization, and they face specific challenges along migratory routes and in destination countries. And so these heightened risks and specific challenges speak to matters of justice in varied ways as injustices prevail. And so indeed, it was this lack of justice in the context of migration as it pertains to gender dynamics that led to the launch of the Center for Migration, Gender and Justice on International Women's Day in 2020, so at the cusp of the beginning of the pandemic. Next slide, please. So CMGJ, or the Center for Migration, Gender and Justice, is a nonprofit NGO that addresses human rights at the intersection of migration and gender through research, advocacy, and education. And in our research, we explore the specific needs and challenges of women, girl, LGBTQIA+, and gender diverse migrants. And we provide recommendations and guidance for key stakeholders about human rights at this intersection of migration and gender. In our advocacy work, we shrink spaces between migrant communities and governing bodies in order to ensure shared agency, representation, and accountability in protecting human rights for all. And in our education work, we bring together migrant communities, non-state actors, and state actors to learn with and from each other about migration and gender, notably, for instance, in our Migrant Youth Leadership Program, for instance. And so while there are many projects that I could speak to today that exemplify this important interplay between research, advocacy, and education to achieve gender justice beyond borders, for today's discussion and addressing some of the guiding questions for this panel, I would like to highlight our ongoing Spotlight project, Migration, Gender, and COVID-19. This project included ethnographic research, so interviews and observations on COVID-19's impact on refugee women's livelihoods in Portland, Oregon. It also included advocacy at various international high-level meetings, as well as speaking to our education dimension, offering English language classes online by one of our colleagues, Jen Ayers, a certified ESL teacher. But for today, I would like to focus on the research component of the project, which of course also informed the advocacy and education dimensions. So between May and July 2020, myself and CMGJ researchers Grace Fordson, Catherine Harder, and Trevor Reitman conducted interviews and observations on COVID-19's impact on refugee women's livelihoods in Portland, Oregon. And preliminary findings from our work have been published already, and some are forthcoming. And this work is ongoing. It emerged as a community-based and immersive practice. And so we're still working on various aspects thereof and have since then also expanded this very localized space within which our research findings are located. And that's what I would like to do for today in this discussion, is to connect these localized community-based efforts to broader dynamics regarding migration, gender, and justice. And the framework for my presentation concerns access to social protections by refugee women specifically, but also migrants more broadly. And so here's what we found and what we did and why. The COVID-19 pandemic and corresponding response measures have impacted communities across the world, and some communities have been particularly affected, while at the same time they have been left out of national response measures. And this is the case for many migrant communities, including refugees and asylum seekers. And so to highlight the specific challenges and needs that migrant communities face during the pandemic, we interviewed refugee women and representatives from organizations working in the context of migration. And we complemented these interviews with online observations of community efforts that provide essential services to refugees. Our research again took place in the summer of 2020 and resulted in findings that point to the importance of providing social protections for all, irrespective of migration status. Our findings show that COVID-19's impact on refugee women's livelihoods operates along three key dynamics: restricted access to resources and services, lack of information about resources and services, and fear due to ever-changing policy. And of course, this is very specific also to the United States. So from losing jobs, and with that, often losing healthcare, to becoming essential workers and to finding oneself again in unprecedented situations of limited mobility, refugee women in Portland have been confronted with concerns about sustaining their livelihoods. And in many ways, community efforts have, at the very least, complemented national COVID-19 responses and measures. Next slide, please. And so while there's much to be said about the specific challenges that refugee women have faced as it pertains to restricted access to resources and services, lack of information about resources and services, and fear due to ever-changing policy, All three dynamics are, of course, interconnected. And if we could go to the next slide, there's a quote by a Bhutanese refugee woman that we spoke to, which speaks to the urgency for justice in the context of migration and gender. The woman had been employed as a housekeeper, but due to the hotel industry being severely impacted by the pandemic, she had been out of work for 3 months, and the woman described the toll that her unemployment had had on her family as quote unquote manageable, and that she doesn't have time to be scared of COVID. Next slide, please. So this quote really pressingly reflects not only the implications of COVID-19 on migrant livelihoods more broadly, but also explicitly conveys the gendered dynamics within them. But then what can we do with these community-based findings, these localized research findings, and how do they relate to broader global discussions around this? Based on our empirical data and our discussion of social protections, we outline several global outlooks that capture short-term and long-term gendered implications of the pandemic in the context of migration. Next slide, please. So these global outlooks involve the inclusion of refugees and migrants more broadly in national COVID-19 response measures, the development of universal protection structures, social protection structures, as well as the implementation of gendered and intersectional approaches in migration research and politics. According to the IOM, the inclusion of refugees in national COVID-19 response plans and the development of universal social protection structures can diminish varied inequities, such as the ones found in our research in terms of access to resources and services and lack of information thereof. Indeed, we argue that these dynamics are interconnected, and so must be the efforts that seek to ensure refugee women's livelihoods. And also in providing outlooks to ensure refugee women's livelihoods during the pandemic and beyond, we also find it imperative to address the lack of gendered and intersectional approaches in migration research and politics. And this is the case for knowledge production, so data collection and analysis, as well as gender responsiveness in policy. So we suggest that gender must be embedded in the planning, in the implementation, and the evaluation of policy that governs the lives of refugee women or migrants more broadly. And we use the rhetoric of migration politics as it spans across policy fields. So not just focus on migration policy, but also social protection policy, labor policy, because migrants operate within these spaces beyond what's specific to their migration status. So just allow me to conclude here by emphasizing that our research points to significant gaps between policy and lived experiences. And we find that these gaps are mismatches in the ways that restricted access to resources and services, lack of information about resources and services, and fear due to ever-changing policy have impacted refugee women's livelihoods. And while these impacts have, of course, been heightened during the pandemic, the severity thereof suggests that existing national social protection structures have shaped and will continue to shape refugee women's livelihoods beyond the pandemic. So this said, we contend that any efforts in ensuring refugee women's livelihoods must not start and end with COVID-19 responses and measures, but that they necessitate really a rethinking of how social protection structures impact refugee women and migrant communities more broadly. Next slide, please. And with this, I say thank you and would like to extend an invitation for collaboration and an invitation to one of our upcoming events, Youth Perspectives on Migration, Revisiting the Istanbul Convention, which was organized through the earlier mentioned Migrant Youth Leadership Program. So we hope to see you there. Thank you.
Sin micrófono.
Muchas gracias y disculpen.
I apologize. Thank you very much.
Y bueno, como decía, pues muchas gracias por
As I was trying
intervención.
to say, thank you very much for your presentation.
Y
And now we are going to give the floor to Felipe Gonzalez Morales. He is a special rapporteur from the UN on human rights for migrants. He is also a professor of international law in the University of Santiago de Chile, where he teaches in the master's degree in human rights. And he also talks about migrants, the Inter-American Commission of Human Rights, and he was president of that commission in 2015. He's also professor of the different postgraduate programs and in different universities in Spain. Since 2001, he's also professor of the American University of Washington, D.C. He is founder and first director of the Center of Human Rights in the University of Portales, and he's also part of the Latin American network of judicial networks in human rights. He has a master's degree in human rights by University Carlos III. Dr. Felipe, the floor is yours. Thank you very much for being here with us. Your time starts now. Thank you very much. Good afternoon and good morning. Thank you very much for this invitation to this forum on justice innovation. The topic of access to justice for migrant people is a key topic for the exercise of human rights in this group. We have been working in this topic as one of the core topics in our work. 3 years ago, we presented a report on access to justice for migrant people to the General Assembly of the United Nations. And in different topics and in different countries, we have been addressing this topic as well, with the objective of reaching certain aspects and groups. In 2 reports related to what Lara Susan was saying, 2 reports on gender and presented by my group 2 years ago from before the Board of Human Rights and the organization. We were talking about access to justice for migrant women. And also last year, there was a report on the migration for children, and they were also analyzing the topic of access to justice, in this case for migrant children. The main thing here is that access to justice is a basic human right for the exercise of other human rights. When we do not have access to justice, the possibility of exercising the other rights is limited. And this is also related to the case of the group of migrant people that, because of their own characteristics and based on migration policies that are in most of the states, are delegated to a secondary part, and they do not have the attention in public policies. And that's why it's very important that these people, the migrant people, are able to have access to it. When we talk about access to justice, we are not only talking about access to the judicial access itself. And I say this because in the case of the migrant group, access to the procedures and the possibility of doing these procedures judicially is very important. It's usually more important than for the people who live in that area, in that territory. For instance, in the process of deporting, these are administrative procedures, and they should have the possibility of having access to a judicial system, which is not always acknowledged by the states according to the international standards. But the possibility of having this legal situation should go through all this deporting process, both in the administration part and in the judicial part. And this can also show what we talk about the right of seeking for asylum and for being a refugee, and also the probability of obtaining the acknowledgement of being a refugee or an asylum seeker increases 3 or 4 times when you have this legal representation. A person that has a lawyer has more probabilities of acquiring the status of refugee. And this is not just casually. This is done because of the agility in which the procedure is done, because this person has access to these procedures, to doing all the steps. And this happens as well with the migration status. At least in the Occidental countries, the decision is not based on the criminal considerations. And talking about removing this criminal classification, it was replaced by an extensive practice of the migration arrest. So in the case of Mexico,
Alberto, hay un problema ahí con... ¿Podemos hablar?
Sí, sí, sí.
Alberto, there is a problem. Yes, we believe there was a problem with his connection, right? Okay, maybe in the meantime, while we recover our communication with Dr. Felipe, maybe we can continue in some sort of interview format, which would be the most appropriate thing to do right now while we recover his connection. And you mentioned about your research and your studies based on gender. And I don't know if currently in this context, in which it seems to be more mobility and more interest from the states in not allowing this mobility and not allowing people to reach their destination, which could be the US or Europe. I don't know if from a gender perspective, we are finding greater challenges or greater violations to human rights or greater obstacles for women that find the obligation of being on the route and moving in order to reach a better life in another destination.
Yes, thank you for bringing up this very important point.
Este punto tan importante, creo que
as mentioned in my presentation, women, girls, LGBTQIA+, and gender diverse migrants face very specific challenges. And one of those to be mentioned that is particularly pressing is gender-based violence. Gender-based violence is not only a cause for migration or for flight, but it also, of course, unfortunately, it also occurs along migratory routes. And so given the frameworks that currently exist with regards to gender-based violence as a ground for seeking asylum, they're very fragmented. So this would be certainly something that I would argue from a human rights perspective needs to be solidified further. There are guidelines by the UNHCR in terms of how to address GBV prevention, mitigation, and response. But of course, each individual country responds to this differently and has different asylum laws as it concerns gender-based violence as a ground for asylum. So this is something that I think certainly needs to be further discussed and further explored and solidified within the legal institutional framework.
Uh-huh. Oye, y en este punto, sí, en este punto, ¿crees que la tecnología ha habido algún
elemento? Do you think
Ah,
that
mira,
with technology there have been some elements? Oh, okay. We have Mr. Felipe Gonzalez back. His connection is back. We're going back with him. We are going to give him the floor again, and then we can continue talking among the three of us when he finishes his presentation. Thank you.
Se me cortó la conexión a internet.
I apologize. I lost my internet connection. I was explaining the importance of access to justice and also in the administration part for migrants. In this regard, I meant the seek of asylum, the migration situation, the process of deporting, and I would add also the process of being regular or having a better status. As you can see, there are different possibilities of having legal representation and being represented by an attorney. That is more important than in the average cases some of the people that are in different territories.
However, the question must not be restricted only to the administrative field. And here, this is not about, as it happens in many countries, where migrant people only have right to public defense in case they are accused of any crimes. They should have the possibility to obtain a legal defense also for their migration affairs before the court. And usually, I would say once the matter has gone through the administrative part. And the second point, which is important, concerns the consulate. It's a human right to have a right to this assistance, and it's part of justice access in a clear way for over 20 years now. The different international organizations like the International Court of Justice, the Inter-American Court of Rights, and other organizations have established that this is a human right, and not as it was understood before as the right of a state face to another one, in such a way that when a migrant person is subject to a process, they have to be notified and not their origin state and about their right to obtain consular assistance because they are fleeing the country, and it's a human right consisting in the possibility for this person to opt for this consular assistance. And we must have a system as well to provide that consular assistance for that right not to be void or something abstract in nature. This is a matter that we have been highlighting. We want states to strengthen their consular assistance mechanisms. It has happened to me as a United Nations rapporteur, and before that of the Inter-American Court, and I have been approached for assistance in terms of migration affairs. It's been the case for several countries in Mexico, in Central America, and other countries in America. This is important. This is a work that concerns not only specific cases, but also the monitoring of migrant human rights. And it's important for consuls to deal with this. There is a specific aspect which is very important, and that's for migrant working migrant women. And migrant women working as domestic assistants, and oftentimes this work is outside the general labor regulation and not just from the legal point of view. In here, the situation places them in a marginalization, and not only economic. If there is no proactive activity, by consulates for them to denounce the facts to which they are subject. It's very important for consuls to pay special attention to this collective, even more when we have a kafala system in countries like most Middle East countries in which the employer, the household owner, has the passport and the documentation, and in the end, it becomes a proxy for this maintenance of the person working at the home. All of these are relevant aspects to be considered. Another important point is the one firewalls, the sanctuary cities, as they are called in America, the establishment of a strong division between access to justice and other public services on the one hand, and migration offices, and in general, the agencies, enforcement agencies on the other hand. Why is this important? Well, we can exemplify this in the context of this pandemic. In most countries, during the pandemic, at least at the normative level, it has been established that migrant people have a right to go to hospitals to receive COVID-19 assistance and health care, and to have access to vaccines. I say a declarative or normative way because in practice, most people don't go to hospitals only in cases of emergencies or life-threatening situations because they are afraid to be detained and deported. Actually, we were seeing this last year in the Dominican Republic, in which several Haitian women, pregnant Haitian women, have been deported, which went to the hospital and were detained there or upon their coming out. So what's the message being sent or conveyed to migrants? It's don't go to hospitals, otherwise you're going to be deported. And we saw this with the courts. If there is no clear barrier between the judicial and the firewall, the migration firewall and law enforcement systems, the migration agencies, the person will not go to court, or they will go only in extremis. When the crucial time has come and passed by, it's a vicious cycle that violates the migrants' human rights because they know, because perpetrators know that the person will not seek the court's assistance because they are afraid of being deported. And we are making this call from the rapporteurship so we can establish this type of strict division between the public services, including the judicial system, and the migration agencies. In this logic, we have then cities with these systems and not the states as a whole. The discussion in the United States during Donald Trump's administration was about those cities not sharing this information. San Francisco, Los Angeles, California as a sanctuary state, so to speak, Houston, Austin, New York, and in general most cities in which we have a significant migrant population. However, as you understand, the topic is not enough when we speak about city, because then the city can act as was happening during Donald Trump's administration. Some financial administrations were being made to restrain or to subtract federal financial resources to stop this firewall actions. In Mexico, what we have is temporary visas for migrant people who have been victims of some crimes. And in the case of Mexico, migrant women who have been subject to gender violence, as far as I am concerned, they are given a temporary visa so they can denounce the cases of which they have been a subject without fear to be deported. This is a basic action that should be replicated by other states. Another relevant point concerns the right to an interpreter, and this may concern the language, the official language of the origin of the migrants' origin. A state or this concerns in the case of Latin America, indigenous languages. Regardless, this language is acknowledged or not in the origin country. If that migrant indigenous person does not understand what is being indicated in a judicial formality, they have got a right to an interpreter that has been established regionally by the Inter-American Court of Human Rights and other agencies globally. I would like to highlight the relevance of judges to be the ones intervening in the protection of the human rights of migrants. Because of the characteristics, we have administrative cases, but before any deportation, assistance has to be provided, otherwise it makes no sense. And we have a kind of broad systems in this sense. We apologize, we have lost audio in the booth. We have hybrid systems where we do not have judicial system judges. We have the Attorney General's office, and they do not belong to the system. I was seeing some recent studies in which an important percentage, about 40% of migrant judges named in the United States during the last two administrations had as last employers ICE and other law enforcement agencies. So in here we have a matter of judicial impartiality. We have to emphasize here the prioritization of judicial management and the possibility to appeal any administrative nature decisions. I would like to go back to the matter of the gender perspective for migration and access to justice. In this sense, all the judicial system with relation to migrants has to have a gender perspective, and we need specialization for the assistance of specific migrant women needs, and we should not use the same approach for everything. That's why I was mentioning the temporary visa example for women who have been subject to crime. This is a matter that we are considering from the reportership that has been strengthened, and that's the impact of migration, and the acknowledge the approach, the gender approach of migration. The old mechanisms were not there. I think this is an important step. So the Global Migration Pact, adopted by all of the Latin American countries except Chile, my country, and the Dominican Republic. I think this contributes to emphasizing Thank you very much. Thank you. Thank you for your contribution and what we were saying before in terms of access to justice. I would like to ask Dr. Susan whether there are some cases or some successful practices because we're speaking about the institutions, the duties, and the things that cannot be improved. However, there are also successful practices that can be common and can be used by for other institutions to learn how to approach the question in a better way. I don't know whether you've got any examples about this to put at the table for other institutions to adopt it.
For the question.
Muchas gracias por la pregunta.
Identificar buenas prácticas. Context is always very tricky because, of course, we're also talking about individual cases or so. I think what I would say is pointing to the increased attention that has been paid on the international level when it comes to gender-based violence, particularly in context of forced migration. Last year, the UNHCR issued a new guidelines and policy practices with regards to this, specifically to gender-based violence mitigation and prevention. And so it's now up to the individual states and also other stakeholders to, of course, take these guidelines and this expertise into consideration as they move into court cases or otherwise any kind of judicial processes when it comes to gender-based violence. I think one other aspect that I would mention here, as Dr. Felipe Gonzalez Morales mentioned, is also the Global Compact on Refugees, the Global Compact on Migration, but specifically in the context of gender is the newly formed Women, Peace and Security Humanitarian Action Compact, which combines concerns about women, peace and security, which of course gender-based violence is a key aspect, with humanitarian action. And so the idea here is, and this is something that I think is important to consider, is that these experiences, gendered experiences or otherwise, they occur along a continuum. They don't stop in one aspect of the migration process, right? So we're talking here about experiences in the country of origin, experiences along migratory routes, and then also experiences in destination countries. And thinking about gender-based violence and the prevention thereof and the mitigation and response thereof across these different experiences, rather than operating within policy silos. I think that this is a good practice that we keep seeing emerging more and more, that we're coupling or that we're connecting different compacts, different policy frameworks with each other, that then show that we're understanding that these experiences operate along a continuum, and that support, access to resources needs to be provided along these different aspects and along this continuum. Thank you.
Sí, quizás ahora ya sería para los dos seguir con la dinámica de ir preguntando.
For both of you, I would like to answer, and you can choose who would like to answer first. When we are speaking about innovation and access to rights, well, in case of belligerence towards migrants and an attempt of countries to prevent their crossing of borders, is there a risk that acquired human rights may be lost? So rights that we were taking for granted may be lost. And I'm thinking about here political practices such as MPP or Quédate en México, stay in Mexico, possible translation, and it is suspended now, but it was there for two years ago. That is not something that does not legalize the express the position out of the border. We are in a context in which a conjuncture can lead to the loss of previously acquired judicial rights, and the floor is up to anyone who would like to answer first. If you allow me, effectively, I would like, as Alberto, you were saying, there is a series of rights that have been kind of diffused or derogated in the last years. And I would say that this inscribes within a context in which there is an important tension of security approach and human rights approach in the migration policies. This is reflected in the discussion on the Global Migration Pact, which is reflected in the international debate between states. This is an outstanding matter at international fora, even if the Human Rights International Fora response is clear. Their position has to remain and prevail, but this is only focused on some rights that concern the life and integrity of people, and this has to be interpreted in a contextualized way. And the examples by Chapter 2 and the Remain in Mexico policy are coherent to this volatility of the migration policies, and this is a common trait to all the world regions. For instance, in the case of South America, we can see how in a very short period, most times almost all South American states have completely changed their migration policy, and in 2018, that's only 3 years ago, they established the Quito process for the Venezuelan displacement in a perspective that was of welcoming. However, it became a series of obstacles to prevent Venezuelan displacements to other countries, and definitely this has increased human trafficking levels. It is believed that there is effectively a reduction in human rights. Now, if we connect this to this panel's topic, I think that we have the challenge here to strengthen access to justice, and things have been obtained. I think the civil society has achieved things in this sense. When we have the public defender offices, autonomous agencies within the state machine that are that manage to protect the migrants' human rights. Of course, when legislation is changing, this is more difficult to achieve, but a judge can always interpret legal norms according to human rights, international law, or the Constitution itself, guaranteeing these rights. I think this is very important in the pandemic context. We have had some interesting examples in which is the Latin American context, and I'm speaking about the state courts besides the Inter-American Court, of course, and these courts have halted any extreme exception measures adopted in the pandemic context that affect migrant people. We have just 5-6 minutes now left, but I don't know if you would like to add, Lara Susan, I don't know if you would like to add something about this.
Yes, if I may, I'll be very brief. And,
Sí, voy a ser muy.
I think maybe one way that I can contribute here is to think about access to human rights more broadly, outside of also the judicial system and migration policy per se. Some of my research most recently, and actually this is part of a research collective on gendered implications on COVID-19's impact during the pandemic, as by the IOM that I'm working on, and I'm contributing a chapter to, is on the right to health for instance, and particularly the right to or access to mental health resources and services. And so, of course, each country itself has particular restrictions with regards to this. Some countries are more open or less restrictive in terms of access to health services by non-citizens, while others are very restrictive. Where in other countries we see it being more restrictive in this case. And I think this is something, of course, to consider, particularly during this pandemic, but also beyond, when we're speaking of mental health resources and services and who has access to them in the context of forced migration. So I did a comparative case study analysis between different countries, and the gendered implications, of course, of mental health are different, and they exhibit or manifest in varied ways. So I think that is, and we can, of course, talk about different areas of human rights as well, but I really wanted to stress here, of course, the importance of health during the pandemic, and particularly mental health as it concerns gendered components. Thank you.
Si puedo comentar sobre eso. Sí, ahí, bueno, me parece muy interesante lo que plantea Lara Susan y que esté
I think
desarrollando.
what Susan was saying is very interesting. This is a topic that was addressed by the Special Rapporteur of the United Nations 3 years ago in terms of access to mental health for the migrant population. I think that's a crucial topic, and of course in the pandemic context has become more necessary to address. In here, I would say that we have several hypotheses. First of all, the migrant population can only have access to health services in emergency cases. Others consider this in a broader way. I think that the pandemic context has broadened this perspective. However, I would like to highlight that this is not a matter of regulations. And that's what I meant with firewalls. The person gets there and at the hospital that they're going to call, look, we have an undocumented person, they're going to call the migration service, and the person is going to say, their country fellows are going to say, like, don't go to the hospital because you're going to get reported. And the other topic here is that what's an emergency? What's emergency here? Because we're speaking about emergency healthcare because of an accident, a person who was healthy and undergone a serious accident. Okay, but there are people who go to migrant people who go to the ER because they are there because they did not receive a timely healthcare, like a chronic disease, for instance. So there probably becomes an emergency because of that lack of access to healthcare under ordinary circumstances. Okay, we have come to the end of this panel, and I know that we would have loved to discuss many more things, but we are running out of time. So I would like to ask each one of you to close in a minute what you think that the main message to convey should be after this discussion we have had. What do you think should be the keys, the outstanding keys? I'm going to give you 1 minute for closing to each. To close our panel, Lara Susan, I'm going to give you the floor.
Thank you. Thank you very much. This is very difficult to do in 1 minute because unfortunately, so many injustices prevail, but I will do my best, at least speaking from it through a gender perspective. I think, and this was reiterated several times throughout the discussion, is that we have to consider that migrant experiences vary. There is no one uniform experience that exists. And with that, of course, access to justice and questions of justice need to be responsive, particularly to these experiences. And when looking at this through a gender perspective, a lot of times the frameworks that exist for protection or access are very broad. They don't particularly look into gender dimensions within access to health, for instance. Does this include maternal health, et cetera, reproductive health, right? So just to give some examples here where I think the general broader approach where we're moving towards to with, for instance, the Global Compact on Migration and the Global Compact for Refugees, we see a more human rights oriented approach there. What is still needed is to really consider the specific experiences and the intersectional experiences that migrants, of course, carry. Thank you so much.
Tu turno, por favor.
Felipe, your turn. I think that we have lost Felipe again. No, he's there. I would like to signal a specific point. We apologize, we have lost audio in the booth. I think Felipe is having connection problems again. The relevance audio quality is bad in the booth. We apologize. I think the state I'm not sure if you were able to listen to all of my contribution, but that was the message I wanted to convey. Thank you very much, both of you. It's been a pleasure to have you with us. It's been important to speak about the current difficulties experienced by displaced people to have access to justice services and the challenges for the latter, for migrants to have access to them, not just in terms of transit, as I was mentioning at first, but also when migrants get to the destination place, that place they were expecting to get to, and all of those difficulties, as it was mentioned by our two speakers. We have the example of COVID-19 and how about the difficulties to get access to health in the last year and a half of a terrible pandemic that we have undergone. We have seen the relevance of the civil society as agents for accompanying and supporting migrants, and likewise somehow to force institutions to guarantee a series of rights that are not always guaranteed, especially in a border externalization context, in a context in which governments try to prevent the transit of displaced people, and ever more people are on the move trying to get to a better life or to save their lives. And in here we also have the difficulties encountered by the moving people in terms of rights guarantee, as can be right to asylum, that has been questioned in the last times, especially with xenophobic policies and rights reduction like those practiced by former American President Donald Trump. So this has been a very interesting discussion, and there are many outstanding topics about which to discuss. We have the role of the civil society or of new technologies that could have been there. Those are the outstanding elements that we could explore in the future. I want to thank the speakers and the guests for having been with us this morning. I want to thank the public for following us. Lara, Susan, Golisoki, thank you for having been with us. Felipe Gonzalez Morales, thank you very much for your participation. And I invite you to continue with us for the next panels of this forum. Thank you very much. Thank you for this discussion and have a great day.
Muchas gracias a todos los que siguen el segundo foro internacional de la innovación en la justicia en este segundo día de actividades. Y bueno, ahora continuaremos con la mesa Injusticia, Justicia, innovaciones que ponen en pugna tus derechos humanos. Modera Ana Dulce Aguilar García, académica de la Escuela Libre de Derecho, y participan Jamila Venturini, de Derechos Digitales, Diego García Ricci, Ibero, Jurídica Ibero, y Luis Fernando García Muñoz, de Red. Muchas gracias.
Good afternoon, everyone. Thank you very much for joining us in this 8th panel in this forum on justice innovation. In this panel, we will talk about innovations that put human rights in conflict. And first of all, I would like to introduce our participants. First of all, we have Diego Garcia Ricci, who is a professor and researcher from Universidad Iberoamericana and director in Jurídica Ibero. He is a specialist in protection of personal data and professor in the School of Law. He also worked in the Judicial Division of different studies, and he has also worked in IFAI, the National Commission of Human Rights. He was consultant and he was a researcher. He is also a lawyer from the School of Law, and he has a master's degree in law and constitutional law in Toronto, Canada. He also has a PhD, and he is author of the book The Right to Privacy, as well as different publications with the right to privacy and protection of personal data. We also have Yamila Venturini. She is the coordinator of Digital Rights, an NGO in Latin America that defends and promotes human rights. She is also a journalist with different studies from the Latin American University in Argentina, and she is also a member of the Latin American Network of Studies of Surveillance, Technology, and Society. We also have Luis Fernando Garcia Muñoz. He is the director of the Network 3D, which is for the defense of digital rights, and he's also a professor of different universities. He's also a student of the master's degree in human rights, and he has a great experience regarding technology and human rights. With no further comment, thank you very much for joining us. And I would like to ask you a first question to start your interventions. We will start with Diego, then Camila. And I would like to ask you, why should we be concerned about technological advancements? Why is technology a concern for human rights, especially when we're talking about the justice systems? Diego, please go ahead. First of all, I would like to thank you for inviting me to participate in this forum. Thank you very much, Ana Dulce, for your introduction. And I would like to greet Luis Fernando and Jamila. I think that it's very important to see the technological developments, because technology is always asking us questions that make us feel sometimes uncomfortable with fears. And there has always been an unavoidable relationship between technology and determinism, that many times we have seen technology as a reality that we cannot stop and as something that we cannot control. We are living a series of events, and the only thing we have left to do is stay put and see where technology is going. And I think that in that regard, we need to be very careful in these technological advancements and see what they are doing when developing these technologies. And this forum makes me think about the decision that Facebook just made a couple of weeks ago of focusing all their approaches in the creation of this metaverse. This metaverse that offers a space of combining the digital reality and virtual reality. And this is everything that we need to know about this metaverse, what type of technology and what type of observations they are going to do about us for it to work. And this goes beyond a mere protection of personal information, because according to what we know so far, most of the success of these metaverse is related to the invasion of our private life, how we react, how we move our eyes, what are our physiological traits. And because we are presenting a certain number of avatars so that we can react before other avatars. And these are going to be related to our behaviors and our decision making. So this is where I think it's very concerning. The things that we are building from the technological standpoint and what Facebook is telling us is that these approaches are going to be focused on augmented reality and virtual reality. And this is what we know how this industry is being developed. And recently, I had checked a publication by some German researchers that talk about how this visual tracking, or what they call eye tracking, is being analyzed by these companies, because this is the foundation of the success of this AR and VR. What can we see? What are we paying attention to? And what they have discovered is that many of our visual behavior can tell a lot about our private life. And that is going to be the seed for the generation of this new industry, which is what they call this metaverse. So we need to be very careful, because previously we were used to a regulation and a structured governance, mainly based on consent. We consented the use of our personal information for the provision of certain goods or services. And this is going to change a lot of those rules on which this digital world was developed. Why? Because what is happening with this augmented reality and virtual reality is to study the eyes of the people, where we do not have an express consent, and people are not really going to be able to approve their decisions. And what they studied was that people do not control where they are looking. And many of these ideas are going to reveal a lot of aspects from our private life. For instance, they can reveal sexual preference. Obviously, they can reveal certain type of physical preference, or just seeing the way in which a person pays attention to someone else. And I think that's what this is being founded onto. And also, all this development that is being given by these great technology companies is not really transparent. There are not enough publications about it, and we do not know what they are being based, what they are basing on to do this. And I think this is concerning, because part of what we can see in literature is that many of the traditional stereotypes, when a certain type of decisions are based on certain types of decisions, these stereotypes are being replicated when developing these technologies. So I think that we are in a moment, a critical moment, because we are having all this development, and we are seeing through this what this is being developed on, and that the economic efforts are focusing on that. But there is not so much transparency. There is not enough access to information, and they are endangering our private life by revealing aspects of our behavior, and even through these eye tracking, our own health conditions. So I think that these innovations are bringing to the table some aspects that need to be concerning, not only in Mexico, but all over the world. And we need to be very aware of this, not only all over the world, but also in Mexico. That would be my first intervention. Thank you very much for the invitation once again. Thank you very much, Diego. And Yamila, I imagine that as a member of the Latin American Network of Surveillance Technology and Society, what Diego is mentioning makes sense for you. So what do you think? Thank you very much, Ana Dulce. Thank you very much for the invitation and for the opportunity of sharing with you. Good afternoon, everyone. I would like to focus a little bit more on how this can affect the justice systems. The first thing that I find important is that digitalization can help the justice systems, for instance, in giving more transparency to judicial processes and internal procedures. I think this is an area in which we still have a lot of challenges in the region. And there are countries in which the requests for accessing information, whether it is for the institutions of justice systems or in general way, are still doing in paper. They demand that people go in person, and that represents for some people an additional obstacle for their exercise of the right to access to information. And even though this is more focused on data privacy, I think it's important to remember that public transparency is fundamental for the protection and the guarantee of fundamental rights that include the right to privacy. Our organizations as digital rights, we depend on transparency and access to information, on the implementation of surveillance systems, and the practices of intervention and communications that are implemented by the state in order to analyze and have incidences in our research. But there are also possibilities related to the support to internal procedures of these judicial institutions, maybe promises of artificial intelligence systems that may offer more agility in the decision-making process. I think that there is a larger trend in the region of adopting this type of system. And I think that it is important to understand what their characteristics are, what they are useful for, and what they are not useful for, what they do and what they do not do, and what are the criteria that we need to observe when we consider implementing these type of systems. In digital law, in Derechos Digitales, we did a research in which we analyzed 4 studies on the use of decision-making systems that are automated or semi-automated by the state in the region. And one of the cases that we analyzed is a case of Pretoria, which is a system that is in the implementation stage in the Institutional Court of Colombia that is trying to facilitate the decision-making process through the presentation of summarized cards and statistical data. This is a system that is not trying to replace human decision-making, but to be an aid in that. So by doing the reflections that we can do in what is the extent in which a person can do, as Diego mentioned a few minutes ago, if they have the capability or the desire to go against a suggestion that a technological system is doing, especially considering the reliability, the neutral standpoint. So it's interesting to think that in this specific case, they are not trying to have a decision made, but they are asking to have additional resources for that, which seems interesting at first. We are analyzing this system, as I mentioned, in the framework of this research. I can share more data about it later, but I think it's important to mention that the use of these type of systems is more complex when it's about making human decisions automated, because it can include a lot of algorithmic biases that can be found in the databases that are being used for its operation. Maybe we can say that a person is subject to the same biases if they are incorporated to a system. It is more difficult to detect and correct them since they have a series of layers and additional complexities. A series of agents are involved in the preparation and the deployment of this system. And the same happens in the case of decision-making mistakes that can have an impact in the judicial area by violating the basic right of liberty or freedom. And in the case of making wrong decisions by these type of systems, we know that this is not simple. Some organizations in Latin America, such as Red or Derechos Digitales, we have a lot of experience trying to identify the aspects of accountability when it's about systems that were implemented in the private sector, or when it's about the operation of different platforms such as Meta, which Diego mentioned about this download of contents. And this can also have a very large impact when it moves to the public area and the judicial systems area. It is because of those reasons that it's fundamental that the decisions on digitalization process and automation processes as well in judicial institutions are based on different discussions by representatives from the different parts that can be affected by these type of systems, that are also based on regulations that consider the boundaries and the safeguards in the case of abuse, and also justifications that take into account not only the need of using the systems, but also why these systems are the most appropriate compared to other solutions that may have an impact that may not be so intense in the exercise of fundamental rights. Those procedures and those impact studies must guarantee that digitalization is not leaving behind people who don't have access to internet, that it's not about an additional obstacle to access to justice, as what had happened in other areas, such as giving economic aid to some areas. For instance, during the pandemic in Brazil, there were a lot of difficulties because the system was exclusively digital and a lot of people were not able to access the system to do the request for support and then have access to their most basic resources. And also this type of impact analysis should take into account the security criteria and as well as the privacy and safeguard criteria regarding personal information. And I think I should emphasize that we need to have a data governance framework that balances the internal needs of the public administration in the case of these institutions, the existing obligations and the best practices in terms of transparency and access to information. But also we need to pay attention to the safety and protection of people and their personal information. And there is a really large amount of topics that we could consider. There are practices of the uses of systems of crime prediction and what Diego was mentioning earlier about eye tracking and all of these technologies, which are very concerning in terms of how these type of systems can be implemented. There are a lot of things with legal frameworks, but I would like to leave these topics for the other discussion. Thank you very much. Without a question, we will go back to these concerns, but before I would like Luis Fernando to tell us about RED, which is an organization that is very innovative in this regard because of the digital rights that we have in our country and in the world. What is the experience or what are the main concerns regarding human rights? Yes, thank you very much for the invitation. This is a very interesting discussion. From our point of view, we have always said that technology has a very important idea in order to maximize human rights. We cannot deny that. And we also defend the potential that digital technologies have to maximize the exercise of rights such as freedom of speech, access to knowledge, education, etc. However, we are also aware, and we have always spoken about this, that digital technologies also represent new challenges for human rights, and privacy is one of the issues that can be highlighted when we talk about digital technologies. And in our experience, we have also documented how many of these trends that Jamila and Diego mentioned have grown in the use of technology by different security and justice institutions with very significant impact in human rights. And this is not only about saying that technology cannot have an important role in the pursuit of legitimate objectives, such as fighting crime, etc. However, it is very important to know how. I mean, it would be absurd to say that we don't have technology in justice, as well as saying that any technology makes that any system is better, which we believe these both ends are very questionable. And in this regard, we have documented for years the proliferation of the use of different technologies, such as surveillance technologies, that represent a greater risk. And I insist, it's not about saying that security and justice institutions should not have the technological tools to perform their activities, but in the same way that they are regulated to avoid inherent abuse. And it also represents not only surveillance issues, but also other issues, such as the automated decision-making machine that is based in algorithm or in machine learning, because of the certain characteristics of this potential of human rights violation that makes it really complex. When we talk about human rights violations, usually the victims of these crimes are aware that they are being a victim, that they are under different types of crimes that are based on these human rights. You know that you are being a victim of this authority action that you consider to be a violation to your human rights, and you can go to these justice institutions to try and change that. But when we talk about surveillance, when we talk about automated decision-making based on the exploitation of your personal information, for instance, those types of impacts that are real, usually the victim doesn't know them, and that stops the victim from having access to justice in order to confront this. But in some cases that we have documented on illegal surveillance or the collection of information in an illegal way with very sophisticated technologies, there are a lot of surveillance types. Even when we can document an important amount of abuse of journalists that were intervened illegally in their communications, having access to justice for this is still very complex because there are no democratic control means for the deployment of these type of technologies. Because what we have seen in Mexico is that there are no controls for the acquisition of these type of technologies, which also encourages corruption, direct establishment by shell companies, etc. But there are also no records on who are operating these systems, who are saying that these interventions should be done, and how this is being used. There is no record of anything. There is a lot of secrecy in this national security institution, and it makes it almost impossible for a victim, even if they detect that their rights are being violated, to have access to justice. So I just have 1 minute, and I would like to mention that this is the problem, but there are also solutions. And it's not only about saying, well, we should not have any type of technology. And well, there are technologies that we should say those should not be implemented. For instance, there are several cities in the US, the European Parliament as well has determined to prohibit the implementation, for instance, of the surveillance of public spaces with artificial intelligence by facial recognition. In this regard, they say this technology is very risky and it does not fit in a democratic society. In the case of surveillance and communication technologies, there are recommendations by the UN where they say, while we do not have effective democratic controls to prove how these are going to be used, we need to stop the commerce of these type of technologies for communications. And it's not only about a previous judicial control that in theory exists. It exists in Mexico, but the exception to these new controls are now the rule in some investigation techniques. And besides this judicial control, we need a control of independent surveillance, which exists in other countries. Also the right to notify the victim, so that the people that are intervened legally in their communications, they need to be notified after that, 6 months or 1 year after that, in order to not put at stake this investigation, and they need to have access to the justice system in order to see if this was illegal or legal. Other types of registration measures is the process of decision-making and the investigation techniques for communications, etc. So there is a discussion that we may say it's about security or privacy, and maybe we need to renounce our rights in order to determine this. And it's absurd, especially in countries such as Mexico, where there is a frequent and unfortunate relationship between crime and the government. And it is absurd to try to set a discussion in these terms when in a country such as Mexico, privacy is security, because it's really frequent. that even the same security forces of the state are involved in crimes. That's why we need to have these robust systems of democratic control. Thank you very much, Luis. I think that since this is Diego's job, I think he will agree with you about these controls. But I would like to go back a little bit to more basic things in this system. And we have a series of resources. For instance, electronic bracelets or these fitness trackers, or also the electronic cameras, and a series of technologies that we have been given as a support. And I would like to ask Diego, regarding privacy, what do we need to take into account in order to introduce this type of technology in the justice system? Thank you, Anna. I think that we always need to be very careful, and we need to pay attention to this technology in the justice systems, because obviously many of these developments are not shared because of several reasons. For intellectual property, sometimes they cannot mention the entrance of these mechanisms, and this is one of the things that artificial intelligence presents. We cannot necessarily mention it previously because it may compromise the intellectual property. And there are some phases of the development of intelligence in which we can do that, and some others in which we cannot, because they can compromise as well intellectual property. So the application of this technology is where we need to pay attention. If it is complying, if it is respecting, if it's not replicating stereotypes. I think that this is what is going to determine if this is a proper technological system or not. I think that it's very important to highlight this, and we need to be very aware of how this technology is being applied and if it's really complying with what it promised to be at first. And as Luis Fernando was saying, in the case of facial recognition, it's being proved that it fails. Despite being a technology that offered a lot of advantages, if we see the specific applications, the mistakes are more. And right now they have decided to displace it, or we have seen the displacement of this technology because it's not ready. So I think that in this regard, the follow-up that was done to the implementation of this technology was very good. So that's why in the United States, more and more states are being added to the prohibition of the use of this technology by the law enforcement, because it does not offer safe results. And also something that Jamila mentioned that I think is very important is having discussions with all the involved parties who are going to participate in the use of this technology, and also the people that are receiving that technology, and seeing if this is being applied legally. I'm not against technological development because I think that we can achieve great things, but I think that we need to surveil it, and we need to be very attentive to doing the necessary steps when it's being applied. Thank you, Diego. And Jamila, going back to this topic, and as you mentioned, we need to have criteria, different criteria in order to generate these mechanisms. For instance of artificial intelligence for the decision making. You said that in the US there are being some algorithms to make decisions on precautionary measures, and they have also had different failures due to what you mentioned. From your point of view and your experience, what are the necessary things that we need to consider when we develop this type of systems? I think that something very important to understand is the type of discrimination throughout the implementation of the system. Sometimes we talk about a bias of the system, and we forget that also databases and the identification of we are going to implement a certain system can also mean a certain degree of discrimination. The fact that we are using data, I don't know, of people that are in a vulnerable situation in order to predict certain vulnerability conditions, for instance, That is something that is happening in Chile. There is a system that tries to predict dropouts in school, teenage pregnancies. These are people in vulnerability situations, but they use a databases that is compounded by people who are in this vulnerable situation. And this means that the state is going to identify these situations in a population that is already under these conditions of exclusion or vulnerability, as you mentioned. So this is a cycle in which these inequalities are being reinforced. And when we think about these systems of predicting crime behavior, sometimes the same happens, because when we have some cases documented in the US, how these type of systems end up reinforcing exclusions and of historical inequalities, indicating that certain neighborhoods where there are greater situations of crime rates, and also they are reinforcing and facilitating the possibility for the law enforcement to do an intervention there. So I think that in this layer, it's crucial to have a reflection on how this process is being designed in a comprehensive way. The fact of implementing, for example, facial recognition chambers with security objectives in the public transportation means that only the people that are using this public transportation are going to be affected by this type of systems. Another people that do not depend on this transportation are not. And there's also a segregation on the type of rights that different populations will have. So I think this is very important in the Latin American context as a very basic reflection besides what I mentioned initially.
Thank you very much, Jamila. Luis Fernando, you were saying privacy is security, but it seems that we always have the opposite dilemma, that there will always be a tension between security and privacy, and sometimes this cannot be overcome. You know the Mexican context. What are the strengths and weaknesses of our institutions to solve this dilemma? As I was saying before, and if I can present this more broadly, in Mexico, and unfortunately there is a collusion between authorities and crime. This is frequent, going through, newspapers kiosk, and you can see on the first page that we had policemen who were kidnapping soldiers that were involved in extrajudicial proceedings or forced disappearances. So in a country with such institutional weakness, both in terms of its design and norms, it's absurd to tell the society that we must blindly trust authorities that are usually caught committing crimes against the citizens themselves, and even crimes like, cyber crime and digital crimes. For me, it's a paradox, and how we imagine this stereotype of a person with a black hood, in a black hoodie, in a basement, hacking and stealing money from people. When there is further evidence of cyber crime operating from the institutions, spying people working in the human rights field. So we have to acknowledge this risk, which is not hypothetical in nature, but it has been proved to be frequent, the risk that authorities themselves are the ones committing crimes and abuses against the citizens. And in this sense, it's not about that the prosecutor officers do not have the means to justify to intervene communications without justification, but when they're going to be using these technologies, we will have accountability about thereof. And it's not the case today. And for years, authorities, even locally, have intelligence technologies, and I will say several. We have seen the purchase of false mobile telecommunications, and we have a mass surveillance. It's not just focalized against a specific person. We deploy these false antennas and we are collecting all of the information that allow to identify all of other people who attended a demonstration. We're speaking about malware, facial recognition in the public space that is happening already in some places like Coahuila, the Mexican federal city of Coahuila. We can speak about other technologies, geolocalization, mass analysis of databases that allow to get information of geolocalization and internet users identification. And a lot of these technologies have been used and for which we have no specific regulation. These are purchased freely by the authorities. And what's paradoxical here is that with the recent reforms to law, if these technologies materialized, if this is appealed at the Supreme Court, it's going to be more difficult for a common citizen to buy a mobile phone than for an authority, state authority, to buy a sophisticated surveillance malware system, because now it's going to be requested for people to give our biometric information to buy a tip when the state authorities are not asked for anything. They keep everything in a secret. We have overprices, and the use of these technologies have no records. We have no type of independent surveillance here and supervision. Again, this is not about preventing the use of technologies, but we have to fight against technological solutionism and the speech celebrating the use of technology in justice systems without questioning the House and the controls that could be in place for this. And this has been mentioned a lot lately, even by being aware of the discrimination risks we could have. We're speaking about a lot of automated systems for crime prediction and sentence definition, like in the United States, facial recognition. All of these technologies have been proved to be biased, racial, gender, that affect specific communities and populations which are already vulnerable, which are affected from the very beginning because of inequality, and it has a differentiated impact on them and prevent them from having access to justice. We have seen cases of facial recognition in which people are detained, as Diego was saying. These are errors, but not equal errors. It's more when we have dark skin or dark skin people, or trans people, women, or people of Afro descendants, and white people are clearly detected by a person from different gender, social, economic, or race conditions are going to be faced. And they say that they are responsible for a crime commission. And here you are there in a pre-trial detention, and this is going to create a very harmful effects, just to mention some. So that's why we're making a call to be responsible, not to be celebrating nor rejecting technology in justice systems a priori, but we have to make decisions about what is valid and what is not, and what is valid. How are you going to have the controls so to maximize the rights and not to reduce them? Thank you very much, Luis. You are speaking about a very difficult issue, and it's a lack of transparency in this type of mechanism, especially in the justice systems, in which we have a lot of solutions that apparently are like, the eighth wonder. And the truth is that we do not have this type of democratic controls that you were mentioning. Now I will move to some questions that we have from the public, and we have a specific one for Jamila. Luis Villarreal is asking whether we have to speak about digitalization or rather about the digital transformation of the justice sector. What do you think about that? We have a lot of digitalization challenges that were not overcome either in the justice system or in a broader sense. That's why, I prefer to speak about digitalization in a more general and broader way. Today, we could be speaking about datafication, so to speak, because many of those systems are based in the collection and processing of countless personal data. and from here we have a lot of the concerns about which we are discussing at this table. There is a speech about digital transformation, but I think that this speech in itself entails an improvement which is intrinsic to digital transformation. So I think this is not an appropriate term, at least from the perspective we are mentioning here, that concerns the fact that the good or the bad in the use of any technological system is in their conditions and the way in which it's such a use is implemented, a system or a technology that is neutral or that is intrinsically good or transformative or bad in itself. What we do have is evidence that specific systems entail a series of risks for human rights and therefore should be preceded by many controls or definitely be under some more strict control in its implementation. Luis Fernando was saying, by speaking about the request by EU and experts of a deferral, and because of the absence of democratic controls in several states, because of the systems themselves. And also we have the lack of transparency and opacity by international global companies that develop those schemes. So those are things that we should consider when we think about the use of technologies in the public sector. And we have to be very careful with that. So that's why I prefer to avoid the digital transformation speech that has a rhetoric, that has a series of values, that has comes from some economic groups that try to promote this in the region, when actually we should be thinking about what we need in our context in Latin America, in our countries, for the specific needs that we have, and not just by a speech that a specific way is the best one or the most appropriate one. Thank you very much, Jamila. And in this sense, Diego, would we need a national public policy to move forward in these topics? What do you think about that? Do we need new laws or different public policies? What do you think about that? I think that we have to pay attention to what is being done globally. And I think that this is rather focused on the design of a governance scheme so that allow for the technological development, but not leaving people aside and not preventing them from the opportunity to take part in the design and the application of these technologies. Yes, this is a topic that concerns us all beyond the perspective of the countries of our region, which are countries that we do not have such an important technological development, but that are good consumers of it, and also in terms of the bad application of these technologies. So when we speak about a legislation, would be risky because sometimes legislation is not the best way to balance the different conflicting forces. But I would opt for a governance scheme and that are structured based on principles, which is basically how we try to balance these conflicting forces that we see. And for me, it is very serious that at the beginning of this administration, we left that national digital strategy aside that have been built in the country, because evidently this was establishing a way, maybe it's less than what exists in other countries, but it opens institutional mechanisms to bring to Mexico those governance schemes that are being brought over or that are being developed in the European Union, at the OECD, in different countries, and a global fora. So I think that I would bet on a governance scheme that tries to balance the different existing conflicting forces around the use of artificial intelligence, virtual reality, and augmented reality, because these are the principles that will allow us to balance this type of forces. Thank you very much, Diego. Luis Fernando, we have another question from the public by Dulce Rebel, and she's saying that at the UNESCO, the recommendation for the ethics in artificial intelligence has just been approved. How will this impact the Mexican justice system. I think that artificial intelligence and its implementation, especially for decision-making that impacts public life, represents a series of important challenges, especially for justice systems. I think that to contextualize the problem, when we introduce an AI system making decisions that can negatively affect people, and they can be for several times, even many that are taking place already without we know and without us being aware of this, and most people being aware of them, that there are systems are making decisions that impact our lives every day. And AI systems are already being used for decision making in terms of who we are going to hire or not. The decision making may be assisted by an AI system in terms of hiring. Or, these are many decisions that have sometimes an AI component. And this can have problems of human rights, discrimination, exclusion, and there are many identification systems allowing or making mistakes that identify wrong people and prevent their access to services, or which accuse them of the commission of a crime. In this way, there is a questioning whether our judicial system is ready or is trained to exercise a scrutiny over those technologies, and being able to determine or assess whether the implementation of these technologies and the decisions being made based on them are violating rights that the judicial system is responsible for protecting. I think it's an important challenge. I don't like the ethic in ethics. I don't like speaking about ethics in AI, but rather it's not a matter of ethics. Ethics sometimes, appeals to the goodwill of people, and I think this is not enough. There must be a respect of human rights beyond the AI implementing agencies bona fide. And we have to question some notions that are very rooted in our system, such as the transparency. What have we got right to know in terms of information? The electoral institution is, from our perspective, in a very responsible way, is fostering the design of an internet voting system. However, audits that are conducted are being reserved because of national security. The national code for processing voting is not public, and it cannot be reviewed by anyone, not even awards systems. So systems can be tested in terms of their vulnerabilities. We do not even have this type of system. So how can the citizens be sure that those systems are not altering votes in terms of electoral justice, and how you can have access to justice and say that voting is not complying with the popular will? And I have no way to show this, because the victim, neither the victim nor the judiciary have the power to conduct such a scrutiny. That's why we have to focus on this system, so we can assess and test and detect the effects of automated decision making and based of technology-based decision making technologies that we can define as AI. And I think that's an important challenge that goes through regulation, transparency, and judicial operators training. So we can make sure that these systems will maximize the exercise of human rights and will not be tools for the violation thereof and go unpunished, which is difficult to appeal at the court. Thank you very much, Luis. Well, unfortunately, we have run out of time. This was a very interesting discussion. Thank you very much. for your participation. Thank you to the public for such interesting questions. And well, basically, not basically, but mainly I will keep some important topics here. Transparency. We always need transparency in the use of technologies in the justice system. It's always very important to have broad discussions to implement this type of mechanisms, democratic controls, and of course, as Diego was saying, in a principle-based governance scheme that allows us to guide the use of these technologies in justice. And it's very important to understand what Luis Fernando was saying. We have to be more critical around the idea of technological solutionism. And from the point of view of Jamila, in terms of algorithms and the use of AI in justice systems, we have to be very critical about that as well. And especially we have to look for further participation from the construction thereof, because this will this will be relevant for us, because it's going to be strengthening what we already know, especially for criminal processes in which we have a selectivity over some groups and algorithms for governance in society, and algorithms have not helped us in this sense. So thank you very much. And I don't know if you have any conclusions to share. We have some 30 seconds for each one of you. So please just open your microphones and go ahead. Well, if there are no further remarks, thank you very much, Diego, Luis, Jamila, and thank you, Max Weber, and the Friedrich Haumann Foundation for this call to this forum. Thank you, good morning, and good afternoon, everyone.
Muchas gracias a todos los que nos siguen acompañando en este segundo Foro Internacional de Innovación en la Justicia. Pues bueno, ha sido muy claro los retos que enfrenta y los retos que se dan. Buenas tardes tengan todos. Seguimos en este segundo Foro Internacional de Innovación en la Justicia. Ha sido muy evidente cómo la tecnología no es un asunto blanco-negro, sino que implica muchísimos retos al momento de su adopción. Y ahí el secreto, los retos para la innovación. La adopción de la tecnología es necesaria para hacer un acercamiento a la justicia. Y sobre esto, nuestro siguiente panel de tecnología e Internet para una verdadera justicia expedita. Moderan Yolanda Cuevas, directora jurídica de Tojil. Participan Julián Culter, de Google México, Anne-Catherine Riedel, de la Fundación von Friedrich Naumann, y César Rodrigo Landa Arroyo, de la Pontificia Universidad Católica del Perú, de la Universidad Nacional Mayor de San Marcos y del Tribunal Constitucional de Perú. Muchas gracias. Le cedo la palabra a Yolanda Cuevas.
We apologize, in the booth we do not have sound.
Yolanda, tenemos un problema. No te estás escuchando. ¿Podemos activar y desactivar tu micrófono, por favor?
¿Me escuchan ahora?
Sí. Listo, adelante.
Adelante. Muy buenas tardes a todos y a todas. Bienvenidas al segundo Foro de Innovación en la Justicia. Soy directora de la Asociación Civil Tojil. Es un honor estar el día de hoy con ustedes compartiendo una mesa denominada Tecnología e Internet para una verdadera justicia expedita. La pandemia, como saben, del COVID-19 cambió mucho los paradigmas que al menos en México estaban profundamente asentados en la aplicación de justicia. En la actualidad, gracias a diversas transformaciones del Estado y las exigencias de la sociedad, las tecnologías y el Internet se han convertido en el fundamento principal para la construcción de una nueva identidad de los derechos fundamentales, pero sobre todo una justicia expedita. Es grato para mí el día de hoy contar con dos grandes ponentes en esta mesa para compartir sus experiencias y conocimientos en materia de digitalización y acceso a la justicia, como es el Internet y cómo la tecnología reduce las brechas y desigualdades en una sociedad. En primer lugar, quiero mencionar que nos acompaña nuestra querida y reconocida Anne-Catherine Riedel, experta en comunicación estratégica y directora de la división.
And director of the division of global topics of digitalization and innovation of the foundation, Friedrich Haumann. Thank you for being with us Likewise, we have the presence of Cesar Rodrigo Landa Arroyo, a former president of the Constitutional Court of Peru, and he has been the judge of the Inter-American Court of Human Rights, and also he has worked in the Pontifical Catholic University of Peru and the major University of San Marco. Doctor, it's a pleasure to have you with us today. And as we have very little time then for your interventions, and we want to leverage all of your experience and around these two topics, both in terms of internet and access to justice, by Dr. Landa, as well as, of course, the long experience of our dear Catherine in terms of fiscalization, innovation, and how this is going to be impacting society, and I mean social media. And I want to deepen the questions and topics that are going to be answered in your presentations. And first of all, I want to go and say how we can use the new technologies and internet in the improvement of criminal justice system. And number two, how can we benefit from the solution of conflicts, of online conflicts? And number three, and third important question, how is the digital gap bridged with the use of new technologies, and which initiatives can be used to help reduce this? And I will first give the floor to our dear Catherine, so she can start with this such an important one.
Thank you, Yolanda, and thank you for the invitation, and good evening from Berlin in Germany. Yes, my name is Ann-Kathrin Riedel, and I'm working at the Friedrich Naumann Foundation as manager for digitalization and innovation. And so I'm working mainly on digital policies, not digitalization in general, so I don't create apps or stuff like that. And we're focusing a lot on platform regulation, what we can do against hate speech on social media, for example, but also against disinformation, especially the one which is unlawful. So we try this, and we need to do this to ensure freedom of speech also in the digital sphere. And I think to ensure freedom of speech, we also need to enforce the law in the digital sphere. I think that's a very, very important topic. And today I brought to you some thoughts, and also perspectives from Germany to this panel, which I hope gives you some impression of our work at the foundation, but also state of the art here in Germany. So I am not a lawyer, so I don't have expertise in law or the justice system also here in Germany in detail. But as I said, I want to bring some perspectives and thoughts with you. So my work is mainly focused on ensuring civil liberties, mostly from the civil society perspective. And therefore I'm advocating, for tools or technology that actually helps the justice system and the police to do a better job, and respectively an adequate job in the 21st century. I think that's super important. But when I look at my country, at Germany, we often say here, and especially a lot of politicians, well, the internet is not a lawless space. And in fact, it is not a lawless space. So the law has to it has to be implemented and enforced also in this digital sphere. And because there are some new crimes or crimes in a different way in the digital sphere, politicians and lawmakers often invent new ways or ideas to solve crimes in the digital sphere. They think of ideas like data retention. Oftentimes here in Germany, even though our court for the Constitution repeals it. And I think it's a very bad idea, because we have a proverb here in Germany, what's in English? We need to find the needle in a haystack, but with a data retention law, we make a much bigger haystack. We create more and more data, and we are not able to find problematic data, problematic information, especially from criminals or terrorists. So we have a big problem here, and it doesn't really solve problems. Same with spyware or state trojans, which politicians often want to implement, but we saw just recently with the Israeli company NSO and the Pegasus spyware, it often affects human rights activists, journalists, and so on, and not really criminals. So spyware is often, nearly every time, a problem when it comes to human rights and also cybersecurity. And also, we often have information that the police needs to solve a problem, like open source in the internet. For example, we had a right-wing terrorist attack a few years ago here in Germany in Halle, an anti-Semitic terrorist attack. And the terrorist, he really planned his attack online in open source form. So it was not in a so-called dark web or behind encrypted chats or whatever. And if the police would be trained better, they could have seen it and saw it. They don't need some invasive tools to find criminals. So what can we do to prepare the justice system and the police better to do a better job in the digital sphere? And instead of using tools or making laws for data retention, spyware, and so on, which is often against civil liberties and often human rights, I think we need to do more basic stuff, also here in Germany. So first of all, we need to train our staff in the police and the justice system better. Often they don't have any expertise when it comes to the digital sphere, the internet, how technology works, and so on. We also need to digitalize the justice system itself. So we often talk about e-government here in Germany and how to digitalize our administration, but not enough to digitalize our courts and police stations and give them tools like basic tools like digital files and so on. So they can solve problems in the digital sphere when they aren't able to receive data, for example, or have the capacity to save the data. And that's really a problem often here in Germany. Also, when it comes to specialists like data forensics or forensics for the digital sphere in general, often the police can check smartphones they got from terrorists or criminals because they don't have the manpower with forensics to check it. A second or third point is salary. We need to pay them adequately because we have a huge competition with the economy. They also searching specialists for all the cyber stuff and forensic and so on. And so we need to raise the salary for people who want to work in the justice system or in the administration who is really specialized in this field. And you asked me in advance also if we need to find new ways for dispute resolution. And I think we need to do it, especially when it comes to hate speech, because we have so much possible crimes. We don't know it. A court has to decide if it's a crime or not. And we need to have quicker judgments and solutions for this. So we need to rethink if we can use, for example, e-courts. And I think that's a way where we need to think more about if we can implement this and speed up trials and so on. And of course, we need to use technology to make the system of the justical system more transparent and control it better. I think we need to talk also about live streaming of courts so that everyone can attend a court ruling which is open by itself, but just if you live in the city and are able to go into the courtroom. And we need to create databases that are really open data and searchable throughout all the courts. So that's not the standard, for example, here in Germany. Databases that are easy to access and searchable through all the courts we have here in Germany. So as I said, we need to use technology to improve the justice system, but we need to use it carefully. So it's not good to just use spyware to like find criminals or stuff like that. I think we need to focus on technology that ensures human rights and civil liberties, because technology itself won't solve any problem. I think we need to keep this in mind all the time, but technology can help us to do a better job. Also, algorithms can help us, but we never should use algorithms in decision-making against humans. So we can use algorithms also in the justice system, for example, to help us sort information or to replace repetitive tasks and so on. But if we use algorithms, especially in this area, we need to make them transparent, and we have a civil society and involve civil society to have a critical view on these algorithms. So as I said, technology support and not replace the human being and the human decision making also in the justice system, but it's super important to solve the challenges we have in the 21st century and to improve also our justical system, and with the help of technology, but yeah, with a we need to think really where we need technology and where it's better to not use it. Thank you.
Muchas gracias, querida Catherine.
Much, Catherine. It's very important what you just mentioned. Indeed, the creation and implementation of technologies allows us to apply a more transparent and efficient technologies that reaches the citizenship, but especially the technological approach that guarantees fundamental rights, and obviously how we can do a better job with the implementation of these technologies that allows us to innovate and be closer to citizenship. I would like to thank you. Thank you very much for this group of ideas that are so important. I think that in Mexico, we are still facing great challenges in innovation. Thank you very much, Catherine. And we will now give the floor to Dr. Elanda. Doctor, I would like to emphasize in your intervention, how can we use the new technologies on the internet for a better criminal justice system? Good afternoon. Thank you very much for this invitation. From the Foundation Mexico Evalúa and also the Foundation Friedrich Naumann Stiftung in order to present these ideas for this topic. Specifically, because of my professional training, my constitutional experience, which is the one that has led me to reflect on the protection and freedoms, especially those referred to digital rights. We live in a society in which communication and technology, specifically with the pandemic, as you mentioned in the introduction, it has led to a transformation of the justice system, specifically in the experience of constitutional justice, which may be also in charge of reviewing resolutions in criminal matters that a jurisdictional organization can issue. And regarding the constitutional processes that originate, for instance, in Mexico, the writ of amparo or habeas corpus or habeas data, they have rights and freedoms in the judicial way that in case these are other resolutions, they can be part of the constitutional area. In that regard, since a few years ago, there is a great importance from the digital media that allow more agile operations for the citizen requiring the service, but also in the judicial acts, reducing the human activity, reducing costs as well, and allowing allowing them to be more transparent and more equal for the creation of justice when we can have these virtual mechanisms of access to it. We can participate in the processes such as the follow-up to the judicial rulings. For instance, in 2019, it started working, even before the pandemic, what we call the virtual part table. In that moment, we could have written complaints, and we could also have them virtually. And this allowed that in that moment, the largest amount of complaints came from Lima, the capital of the country. And this was a 60%. And due to the pandemic, this has changed. 60% of the actions that come to the Constitutional Court come from outside the capital, from the different areas, which means that there is a greater access to judicial procedures because we avoid the movement from one place to another in order to present a claim and the need to go to the court that has the headquarters in Lima. And there has also been the authorization of the digital signature or electronic signature. So in 2020, there was a regularization for the access, reception, and procedure of the digital files where citizenship can have access to the system and know what the process they are in is. And there are also some hearings because of this inability of being in person. Both the lawyers of the different parties and even the interested people are able to see virtually these hearings in order to hear the argumentations of the parties. And this has allowed access for the people to perform their oral presentations. But the most significant part here is that the virtual capability right now of these hearings has allowed people to hear this live streaming in some significant cases. For instance, before the corruption in 2019, the president dissolved the Congress based on a foreseen constitutional framework, and this was a judicial controversy, and it created a conflict of competencies in which the whole citizenship, before this fact that had not seen before, in order to face the corruption from a constitutional framework, people wanted to hear the argumentations from both parts, and the Constitutional Court ruled that this Congress should be dissolved. But not only do we have hearings, but we also have these electronic files that I mentioned, which are very important. And also, these rulings should be registered digitally in the website of the Constitutional Court. And from this information, they systematize the case law based on different criteria, whether it is because of the rights, because of the freedoms, and other constitutional concepts. And any citizen may have access to the website and find, starting with one word, the thing they are interested in, starting from the ruling as well. And this also expands to reach the databases of other courts, such as the Inter-American Court of Human Rights, that allows us to reach this information from other constitutional courts as well. And I think it's important to see that there is a possibility of improving the system. because of course there is a better use of the justice services through constitutional application of these virtual systems, as well as its scope, virtual hearings, as the electronic signature, digital files, as I was mentioning, and also case law. The important thing about this is that there are rural areas in the country that do not have access to interconnectivity systems. Because even though there is a network of optic fiber network for the most vulnerable groups, there are no options for them to be incorporated. So I think that it is important that we have different policies to improve access of the population so that they can maintain the constitutional justice in order to approach those who have access to these services, but there are also other policies to have more interconnectivity and give people, low-income people, the instruments that maybe the hardware or the software for vulnerable people so that they are not vulnerable or discriminated. I think we have a whole world ahead. And if you allow me to talk about internet connectivity and even robotics, that little by little are taking countries to new places. So it's important that we give these leaps towards new technologies, these fourth generation technologies without displacing people, but considering to integrate those who are alienated. Thank you very much. Thank you very much, Doctor, for your great participation. And before closing this panel on the internet technology to guarantee a true justice, I would like to finish with this important question, and I hope you can both give me your opinions. How do you conceptualize the hate speech for it to be applied in this virtual globalized environment? I will repeat it. How do we take into account hate speech to be applied in this globalized virtual environment?
¿Me escucharon, perdón?
Sí.
El tema de las tecnologías y obviamente...
Regarding technologies and how we can use them. And Catherine, do you have something to say? Thank you.
Yeah, thank you.
Sí, muchas gracias.
You know, when it comes to hate speech online and platform regulation, for example, first of all, as I said, we need to rethink, or not rethink, but try to find ways how we can improve our justical systems or make them fit for the digital age. So there are some people, lawyers who are trained in law, I'm not, who think about things like e-courts and stuff like that. And I think that sounds often interesting, but I'm not an expert on this. But I think when it comes to hate speech, we also need to focus on something else, because even though we have perfect systems, technology that will support lawyers, judges to rule about hate speech, there will always be massive hate speech online, because I think people in general are good, but there are also a lot of people who have fun insulting people. So what can we do against hate speech? And I think there we need to focus on the systems, on how platforms work. And that also showed us the whistleblower Frances Hong just recently with her Facebook papers. We need to focus on the algorithms that make hate big, that spread hate on social media platforms such as on Facebook or Instagram, YouTube, or whatsoever, because I think there is also a lot of, like we say, music where you can regulate stuff, because we will never bring all of the hate we have online in front of a court. So we need to adapt or do a little bit more on different stages when it comes to hate online, and especially educate people that, as I said, the digital sphere is not a lawless space, and that they will that it will affect them, like physically, the victim, and also the people who write hate in the internet and insult people, and they have to recognize and feel the justice system.
Muchas gracias, nuestra querida Catherine. No sé si tenga algún comentario. Doctor César, para cerrar, por favor.
Do you have any comments? Yes, hate speech is classified in the international treaties, in the Inter-American Commission of Human Rights, in different areas such as violence and discrimination. Having these regulations related to freedom of speech in digital media, this is very sensitive, but it's not impossible to have a certain control where there are violations to freedom of speech. But in the legislations, we can also have different regulations, such as Anne-Catherine mentioned, because the designers of artificial intelligence and algorithms are people, and they may have the capabilities and the training to have these adjusted to the legal framework of each country and to identify hate speech, which is something that happened with Trump, who was expelled from some platforms, which has also allowed to move the state divisions to the great digital platforms who are going to determine who will be able to establish the boundaries of freedom of speech and the implementation of ideologies. So I think that the states are moving forward with digital platforms, but for instance, Facebook has created a lot of things to assess this, and I think the state, not only individually, we require an international treaty, a specific agreement on this hate speech, and I think that there are going to be countries that are more sensitive or less sensitive to these topics, because I know that we have different democracies all over the world, but we require an international consensus to, I believe, create this under the different values of democracy so that we can avoid hate speech or investigate with the due process and penalize or remove people from these platforms as it should correspond. Thank you very much to both of you, Catherine and Dr. Landa, for your great experience. This was a great panel. We need to finish, and I want to thank Mexico Evalúa and the Foundation for these enriching panels, and everyone have a great afternoon. Thank you.
Buenas tardes, muchas gracias. Continuamos en este segundo foro internacional, la innovación en la justicia. A continuación presentaremos un video en el que mostramos que aunque es necesario innovar y adoptar la justicia y el acceso a la justicia, a las diferentes tecnologías, este acceso no es igual. No es igual el acceso a la justicia, a las tecnologías. Hay muchísimas desigualdades, brechas tecnológicas, brechas económicas, brechas culturales que no permiten este acceso homogéneo. Tampoco hay un único concepto ni una única justicia. Y de eso hablaremos en este video. Muchas gracias.
The single access for everyone. Thank you.
La segunda edición del foro surge bajo la premisa de que la justicia debe evolucionar, transformarse y adaptarse a las nuevas formas y mecanismos de hacer justicia, no siempre judiciales. Entender estas nuevas formas y herramientas permitirá consolidar sistemas de justicia adecuados, con enfoque de derechos humanos y perspectiva de género. Es necesario reconocer que mejorar la justicia es complejo de entrada, debido a las desigualdades de base a las que se enfrentan millones de personas. En este sentido, es importante saber que la justicia se ha dividido en diferentes tipos con el objetivo de atender diferentes necesidades. La justicia distributiva se entiende como la distribución igualitaria de los bienes en la sociedad. Busca promover una vida digna y de bienestar para todos los ciudadanos. La justicia retributiva está enfocada en impulsar a los ofensores o infractores a responsabilizarse de su actuar y resarcir los daños ocasionados a las víctimas. La justicia restaurativa se enfoca en las personas víctimas y en el interés de la sociedad en restituir a las personas que sufrieron daños, dejando de lado el enfoque punitivo de la justicia. Se le conoce como justicia transicional a toda la variedad de procesos y mecanismos asociados con los intentos de una sociedad por resolver los problemas derivados de un pasado de abusos a gran escala, a fin de que los responsables rindan cuentas de sus actos, sirvan a la justicia y se logre la reconciliación. La justicia abierta es un modelo de gobernanza que parte del concepto de gobierno abierto, que es un mecanismo basado en la transparencia, la rendición de cuentas, la participación ciudadana y la innovación tanto cívica como tecnológica. La esencia de la justicia abierta es que la ciudadanía sea el eje del servicio público de impartición de justicia y que se atiendan las necesidades ciudadanas en soluciones innovadoras, que fomenten la transparencia en el quehacer institucional con una visión colaborativa entre instituciones y ciudadanía. Todos estos tipos de justicia reflejan la evolución de la ciudadanía hacia una sociedad más justa, segura, igualitaria y equitativa. En esta segunda edición del foro nos acercaremos hacia cada una de ellas desde diversas perspectivas, siempre basados en el respeto a los derechos humanos, la diversidad y el respeto a la pluralidad.
Bueno, continuamos con nuestro foro.
We are going to continue with our forum.
En nuestras redes de México Evalúa.
Please follow us on our social media in México Evalúa, and please visit our website
donde tenemos diferentes propuestas de análisis y de propuestas de
where we have
políticas
different
públicas para
proposals
los
of
temas de
analysis
coyuntura.
and
A
public policies for
continuación
these topics.
hablaremos de justicia restaurativa
Now we are going to
y
talk about
retributiva,
restorative and
dos de las
retributive
justicias que
justice, two
presentamos en
of
este
the
video.
types
Y
of justices
moderará
that we
el doctor
presented in
Guillermo
this video,
Cepeda
and we are
Lecuona
going to
del
have
Instituto de Justicia Alternativa del
Dr.
Estado de
Guillermo
Jalisco,
Cepeda Lecuona from
con la
the Institute of
participación de
Alternative
Marta
Justice from
Angélica
Jalisco,
Galicia Osorio,
facilitating. And we also
coordinadora de la
have the
Clínica
participation
de
of
Medios
Marta Galicia
Alternativos de
Osorio,
Solución de
coordinator of the Clinic
Conflictos
of
del
Alternative
Instituto
Media for
Tecnológico
the
Autónomo de
Alternative
México,
Means for Conflict
Gema Varona
Resolution,
Martínez,
Gema
del
Varona
Instituto
Martínez
Vasco de
from
Criminología,
the Institute of
Fátima Leonor
Criminology,
Gamboa Estrella,
Fátima
de X
Leonor
Justicia para
Gamboa
Mujeres.
Estrella from X
Le cedo la palabra
Justice
a
for
Guillermo
Women.
Cepeda.
I will
Muchas
now
gracias.
give the floor to Guillermo Cepeda. Thank you very much. Thank you. Hello, how are you? Good afternoon, everyone. It is a great pleasure to greet you in this panel, which is very promising with the questions and because of the quality of the speakers that we have in this panel. I would like to thank México Evalúa for the invitation as well as the foundation. It is a pleasure for me to be here to talk about retributive justice and restorative justice. This idea that restorative justice has the challenge of calling all people that have been part of a conflict and even working on it in situ, in the place where this was committed. It started in community topics and then it evolved to criminal areas. As the video mentioned, we help the victims in the grieving process with a full repair, not only in the judicial interest, but also in their needs, their personal needs, which also goes beyond the repair of the damage, and it's been very successful in different topics in family areas. According to the National Census of Justice application in 2021 by INEGI, 92% of the alternative methods that are being applied in the country, in Mexico, 92% is mediation, and then we have arbitration, and then we have conciliation with 4%. And this is a great challenge that we have in the city of Guadalajara. Mr. Raul Calvo Soler mentioned in a conference yesterday how we have this, how can we certify this group of capabilities so that we can call it restorative justice when we are doing this transformation of the relationship of the conflict, this emotional alchemy, as some people call it, that we can use it in this regard. And one of the questions that we have for this afternoon is how is that the articulation of the systems helps boost and make justice more efficient with an approach that is centered on victims, and how can we improve the processes of individual and collective repair through the innovation and the use of technology, not only in the methodologies that the arbitrators have that have created some dynamics in the different congresses and alternative methods, where they are sharing these very powerful tools that are also boosted by the use of technology, but also through the challenge that it implies. What are some of the best practices identified? And I think that this space is very good in order to share them, and what lessons we can learn in Mexico from these best practices. What are the best challenges for the understanding of restorative justice, and what are the first steps for its establishment? As our facilitator mentioned, we have 3 specialists here who are going to participate. Marta Galicia Osoro from the Technological Institute in Mexico, who was also trained in the University George Mason, and she is in the Clinic of Alternative Methods. She is an independent consultant in different organizations. Also, Gema Barona, permanent researcher in the Institute of Technology from Basque Country, and also Fatima Gamboa from X Justice for Women. It is a great pleasure for me to have you here. We have great expectations from your interventions, and we are starting to talk about this topic on justice transformation that will help us to have a better justice in our communities. So we would ask Marta Angélica Galicia Osorio if you can please start your presentation. Thank you very much, Guillermo. Good afternoon, Gema, Fatima, and everyone here. I would like to thank you for the invitation. It is a pleasure for me, and I think that what I'm going to say is always very important, and in 10 minutes, I'm not going to fulfill all the needs of information that we have here, but I think that this can be a good start. I would like to talk about how the participation of victims worked in the justice system, the previous justice system before 2008, where we started the new criminal system. And what happened is when there was going to be a pardon, when this was allowed in the criminal area, the lawyer that represented the offender along with the experts and the district's attorney's office, they were trying to reach an agreement through this pardon. So if you see here, people that are directly involved were erased or were removed, were out of these decisions that in the end of the day were going to affect their lives directly. So from the moment of the reform of the National Code of Criminal Procedures, and we also generate the National Law of Alternative Conflict Resolution Mechanisms in criminal law, that's when other possibilities opened in order to allow the participation of the victim, of course, but also for the perpetrator as the person that is responsible. And it is here where these principles of restorative justice, of repairing the damage and satisfying the needs of the involved people, they can materialize those on the law. Why? Because it is them, both parts, who can propose and determine and define with the help of a facilitator, first, what damages this offense has caused, because one offense can create different damages in different people. What does it mean for me to receive certain offense can be different for someone else, and I may have different needs for the repair of the damage. And this obviously is something that a judge is not something that is within their scope for them to be able to do it. So with these reforms in which they allow an agreement or the changes in the procedure, is that people involved will be able to participate through these facilitators in the restorative procedures that are already trained in order to identify their needs and how they need this to be done, and they are going to support them to reach these conclusions. Unfortunately, it is a practice that, as Mr. Guillermo mentioned, this is something that is not done anymore. One, because there are not enough trained facilitators in restorative law, because it's not the same, and no one knows these processes. And when I say no one, I mean the different district attorneys' offices and the same operators of the system do not understand what these parties should be doing in this restorative or retributive justice doing. And they do not understand why they should go, and they reach an agreement that sometimes they do not understand why they are doing this, because they don't understand that the parties are establishing their needs, which is different to the technicalities and what a lawyer can establish in an agreement. So sometimes because they want to make this more agile, or because they want to close a case, they do not inform the parties, and when they report to the parties, they don't know what they need to report to them. So they don't really understand what a restorative process is, what arbitration is, what they can expect from this procedure. So this has been decreasing. The process itself is only 3%, as it was mentioned. The people who can use these restorative procedures is only 3%. So this means that this has not been spread, and this culture of stopping penalizations and not requiring a great punishment that is going to end this offense is actually a lie, because the need is that the parties are still there no matter how many years they are going to have to be there for a ruling. It's not going to be of satisfaction for the victim, the perpetrator, or the community, because you are not allowing it to be the proper tools for the person to change this situation. So I think this is one of the greatest challenges, to be able to give the operators of the system the information of what is the philosophy of this alternative means and restorative justice, and also than going to the people, the users, or the people that need these procedures.
We need a lot of aware reasoning, both of the system's operators and of the heights from prosecutors, decision makers, because sometimes we have states where things started to, well, the Mexican federal state of Baja California, Querétaro, we could mention several ones in which we were having progress, but then the administration changes, the heads are changed. Many people say their farewells, people who have already established a working way, and we start from scratch without having any guidance, without our understanding the mechanisms and what they are designed for. I think that we have waste human resources a lot, and we always need, of course, investment both in infrastructure, but above all in training and awareness raising of all those involved in these processes. And in here we can have technology, and we can show successful cases through videos. Of course, right now we have used a lot during this pandemic electronic media for these processes. This has to work, and this is a way to engage technologies. But but not just. We can help you and use social media so we can disseminate these ideas, these small examples and success cases. Many things can be done, but our main challenge is to support people so they get to know these mechanisms, and we change that mindset that by punishing people we're going to end up with a crime. I don't think this is working. Even if we have the army in the streets, we have had people lynching criminals, and even if sentences have been increased, so we have to have a different approach of justice administration. I hope we will have the opportunity for this. Thank you very much, Guillermo. Thank you, Marta and Angelica. Thank you for your intervention. Now we will give the floor to Heima Barona Martinez. So welcome. The floor is yours. I am afraid your microphone is silenced. Yes, I think you can listen to me now. Good morning, good afternoon, good evening in Spain. Thank you to the organizers for the invitation by Guillermo to be here with my women colleagues. And I want to resume what Marta was saying. I think it's very appropriate. I'm going to be speaking from a rather European and more particularly Spanish perspective. I think that what Marta has just said, these are questions that, and I would dare say from what we know in terms of the Restorative Justice European Forum in all of the countries, we do not know the performance of judicial operators above all in terms of the restorative justice principles. However, we have got some international legal principles which are universal, and I mean the United Nations principles of 2002 with a new manual of restorative justice manual, so from 2020 for its second edition, and we are detailing here, and we have even a new chapter in terms of serious crimes. And I think this is very important to highlight. Restorative justice arose in Canada in the mid-70s as justice for petty crimes and also for minor crimes, something that we considered in a globalized way in the other 5 continents, of course, with a different impact. But the truth is that restorative justice has been extended to all other countries, and it has extended always marginally to adult and serious crimes, and very serious crimes, I would dare say. And as we will say, restorative justice is not a transitional justice, while transitional justice can be conducted with a restorative aim. But as Marta has said, a restorative justice aims at changing the system restorative justice is complemented because we will always need a criminal code establishing what a crime is and what is not. However, that criminal code can consider other type of responses. We can have a criminalization so long as that behavior is as serious enough, respecting all of the minimum principles for it to be considered in the criminal code. But that does not mean that we must have first of all, freedom restricting sentence, for instance. We already spoke of a third way, and this is repair. And also we can use this in criminal law, as Marta said, it is a repair that can be individualized for the specific case. And there is a third leg, so to speak, which is community, the closer the community. And it's important to highlight this, otherwise it's going to be confused with mediation. Restorative justice is not mediation and it is not therapy. This is very important to say this. There is a risk for restorative justice to be therapy. No, these are therapies. They can be therapies, but restorative justice, it teaches us to administer justice and not to have therapy. Of course, this can have therapeutical effects, but this should not be compared to forgiveness, which is a very complex matter, and forgiveness can be in a restorative program if the people there are involved, but it's not always the case. So the potential of the restorative justice is willingness, and this is what makes it different from classical restorative justice. Is voluntary and not just the author, but also these are representatives of the community, not just through the facilitator, of course, but it makes a lot of sense, and that's why we're trying to promote, specifically in the Basque country and in the rest of Spain, through circles, conferences, panels, which are not just bilateral mediation, arbitration, and it's important to consider the justice concept, not abstractly, but that the one that stems from the injustice undergone by the victim, that can express it in their own words, which is not the same as a classical justice that revolves around a punishment, which is to listen and to repair. It's not mine justice, as Tim Charlton was saying. It's maybe the less walked and the most complex path, because it requires of time. So we cannot say that we have restorative models if we do not have investment in those restorative models. If we do really don't have training that way, it's very important. The European field, the repair of victims. The 2012 directive for all of the European Union has considered restorative justice within the rights of victims. And this is very important because restorative justice was not born there. It was not born in the framework of the victims' rights, but with the time and the development and the different contents, it has made us see that victims are interested in this. Why? Because it is a justice that allows entry to victims, first of all, not with set on stone vision, and it allows for people to come out of the cliche with which justice, the classical criminal justice, has trapped them, and allows us to see that victims are there, especially for serious crimes, and that the idea of repair is together with prevention and the powers of law. We have seen that prevention is completely unrelated to repair, and we teach students special positive, negative repair. And when we hear and we listen to victims, because they want to take part in this because of pro-social purposes, because and never again against anybody else. And in here we also have the transformation idea. Therefore, restorative or transformative justice, if it is identified with an interpersonal matter, or even personal and personal healing, it's going to lose that justice leg. But the idea of restorative justice is not the abstract justice. as a charismatic philosopher was saying, this is a justice administration of justice specific of a specific person of a specific body, either a woman or an intersectoral perspective, of course. So we can say, what are we going to do with that damage, so we can transform the conditions that made it possible, that enabled it. And finally, this is a very complex topic. We'll go to the technological field, in which we have published in the Victimology review, Victimology, possible translation, and a survey, a limited survey that we conducted during the pandemic in terms of how restorative justice was administered through video conference platforms. And results are paradoxical in nature, because while they are being well used in terms of preparatory meetings, we have even had programs in which we can see people in circles within the video conference. The truth is that even if this has a positive aspects, and even as a way of communication, this can allow to think people further and not speak in a certain way, and we can prolong the reflection process if wanted. However, this has very frustrating results in terms of face-to-face communication. And face-to-face communication is very important for restorative justice. However, technology has deficiencies in this sense, and it's some kind of oxymoron not being able to meet face-to-face. Thank you very much. Thank you very much, Hema. Thank you very much for your intervention. You have very interesting lines of reflection, very important ones as well. Now we will give the floor to Fatima Leonor Gamboa Estrella. The floor is yours. Good afternoon. Hello, how are you doing? Hema, my colleague from ITAM. I'm sorry, I forgot your name, Guillermo. I would like to, in the same terms, I would like to speak about the contributions by indigenous justice to Western models of justice, including restorative, retributive justice. And who would say that under a racist and discriminating system, that in indigenous justice can make the state justice being innovated? And from what we have heard, and especially Mayan women colleagues from Yucatan, and they have helped us to think again about the concept of justice if we are looking for responses that are effective face to violence that we are facing as women, because most people cannot have access to justice systems. So I think it's important so we can think again about justice, to consider the facts that are creating injustices, which acts are to be prevented, who are the perpetrators of these acts, in which context they are taking place, and especially, as my colleague was saying, on which borders. And we have to analyze whether these acts are governed by a systematic history of exclusion, colonialism, and the lack of diversity, this splendid ludus removal that maintains the status quo here. So what's justice? If a woman victim is a trans woman, or is an indigenous woman, or if it's a lesbian woman, how will repair take place if this is not just an individual right, but these are also collective rights? And how are we going to repair or prevent those injustices? And if they are not considered in a specific temporality, this comes from a story that repeats over and over. So from this, we know that for Western law, justice, and I think that's the concepts that we all have in mind, those of us who studied law, so it's give to each their own. But if you see, this means that there is someone above all others, and who is deciding what everyone deserves. And also implies that there is an order and a status quo that is to be preserved. And unfortunately, in that order, we have had exclusion and discrimination. And from here, we are breaking up with justice between equals because there is someone who has more power and defending an established order. So what is justice? What I want to share with you is the concept of justice of some communities in which we have been working with Mayas and Yucatan. And justice here, the word justice does not exist as such, but we do have Maloptan, the Maloptan word. And using a very bad description, this is some kind of like the good or the right word. What comes out from the word to be worded through voice to enunciate something appropriate. If you see in this description, there is no someone, a subject. This is what comes from the voice, from the body. For the good word, this is about the voice, taking the voice out. And by doing this, we can take the experience out, the expectation out, the need out, the whole of the body out, so the history. And this makes indigenous systems to be very oral in nature, because in writing we're going to get lost. In writing we will stop listening to each other, and listening is another of the pivotal elements for indigenous justice. And I'm going to quote Baba Siana, Justice Mayan promoter, and what she says to justice is and what she wants to live well. And she says we want them to listen to us. We want them to pay attention to what is happening to us. We want them to know what we are living. I am a person equal to the others, and I deserve to be happy. Listening and voice through dialogue allow to place in an agreement space an experience, but also to recover something that can be expressed by, but not only by voice, feelings. For this, Mayan women are part of justice because feelings are part of healing. Women who seek a community authorities do not necessarily go there and enunciate conceptually violence or a crime in an abstract and personalized way. Women go there and declare to the authorities what hurts them, what makes them sad. And again, in here we are recovering this feeling, what they need to be at ease, what they need to be happy. So through this feeling that is initiated through this voice, through the dialogue process and listening, what is created through indigenous justice, or one of the important components that is created is empathy, which is another of the characteristics of indigenous justice. What do women want from authority? Do they want a punishment, prison, vengeance? Some of them do. But for others, it's not necessarily the case. They want to teach something. They want to create a learning. And as Hema was saying, they want to prevent this from happening again, because what happens to me is going to happen to the family and it's going to happen to the community. So we see how punishments are not necessarily individualized punishments. These are punishments in which we have the community, and through what we call chapeo, community work, like sweeping a school, we're going to be generating speeches that are important for women because they place the responsible person at the center and not the victim. And in terms of gender, this is important because we know that patriarchy has made it very easy to violence authors, mainly men, to never appear, in the speech of the different types of violence, and we place at the center this person. And I'm afraid that I won't be able to tell about more elements, but I think it's very important to start to think about justice again, to think about justices again. So through what we need and what we want, depending on the context of the body that we are occupying, we can really be inclusive and really achieve equality and non-discrimination. Without this starting from the beginning, from the origin, what justice is and for whom, I think this is going to be very difficult, and we're going to continue going around and around the punitive justice system. Thank you very much, Fatima. Thank you very much for your intervention. All three interventions give us pathways for research, for reflection, and I think that we can integrate them in a very positive way when we reflect upon what has been said here around the topic of access to justice, as Martha and Angelica was saying at the beginning. This access to justice that has must have an open justice approach, but also an accessible justice. We have to understand the terms in which we are following this process, a pivotal element of restorative justice, the protagonism of a criminal case, as we were mentioning, but also in the community setting. It is being applied very successfully in family law. The challenge that Martha was mentioning, which is in our system, sometimes is to re-victimize the victim. The standardized model, which is only being implemented in 10 Mexican federal states, and in the rest of the country, we are receiving the file, and it's sent to the investigation unit. And after a re-victimization, we go to the next agency. As Heima and Martin Angelica said, the institutional system and the institutionalized system is related to the criminal agreement to repair, but it is more than arbitration. However, the National Criminal Code in its Article 187 says that the repair agreement goes only for unintentional crimes. And if we generalize here, if we simplify, for a non-violent wealth crime. That's why we have very little such cases, and they require further time, more training, more resources. And the code establishes 30 days for our repair agreement. We can extend it for 30 more days, but in the case of the Mexican Federal State of Jalisco, in which we have trained arbitrators who have followed courses in Spain and other places as well, it seems that we only have an agreement, the repair agreement, but also for serious intentional crimes, they want to introduce restorative justice outside any legal term, even with, as it has been said, we do not need an award. This has to be fully voluntary. And also in some criminal procedures, we can have preparatory hearings to persuade the parties. They're going to sell to the parties because they see no benefit. Okay, this is over. Forgiveness, repair agreement has been reached. But the relevance for the mourning of some people, for victims of who have lost their lives, a limb, for instance. And this goes for the person, for everyone in this process. We have to work more on the criminal system to open further windows for restorative justice, and not limited to only repair. 140,000 repair agreements are reached in a year in Mexico. And institutionally, we should work on Windows and apply the standardized model to end up with revictimization. And the cases presented by Fatima, the original community justice that comes from the indigenous justice has this perfectly compatible component, orality, empathy, like the lawyer saying, they're working with cases that the arbitrator, the conciliator in terms of restorative justice, will work with speeches, with narratives, and well, an attorney only ask a yes or no. Otherwise, the theory of the case is not going to hold. In here, we work with narratives, taking into account the needs of the parties. And as we were saying, the legal system is going to focus on this, and that's why we get the justice we get, because the Violence Act is based on the perception that they were treated without justice, and this is an unsolved case. This is like paving a crater, and for the next eruption, this is going to explode. So we have a very deep lines of reflection given by the panelists. I remember someone from Barcelona in a course, and she was saying, what does the law say the victim needs and can have access to an attorney, a free attorney? What do victims say? Why me? The law says that we need an emotional support center. What do the victims say? There are, in terms of their own needs, I am vulnerable, I am at risk, so they can attack me again. So the victims' concerns are not being addressed by legislation, and I think restorative justice is going to bridge that gap, is going to address that gap, and between the traditional vision of solving the case and the urgent need of this restorative justice to address the core of the conflict and reestablish somehow the social tissue, which is the great contribution, besides of caring for victims of restorative justice. So we can continue reflecting upon this in Mexico this evening, in Spain, about this agenda. And I hope that we will still have this. Thank you to the organizers for this space. We invite you to continue with us in this forum. Thank you very much for your participation. Greetings, everyone.
Muchas gracias a todos aquellos que nos han seguido en este segundo Foro Internacional de la Inauguración en la Justicia, en su segundo día. Han sido hasta ahorita muy fructíferas y muy interesantes todos los paneles, y así seguiremos durante la tarde. Tomaremos un receso para continuar a las 15 horas con la sesión de justicia climática, la responsabilidad de los tribunales, la responsabilidad histórica y su responsabilidad actual. Muchas gracias.